Good afternoon, everyone. My name is Stephanie Okola, and I'll be the facilitator for this afternoon's panel on how to help clients when asserting their rights doesn't work or might work against them. I'm a family law lawyer, and I also do work with Children's Aid Society. I focus the majority of my practice on working with vulnerable people, so this particular panel is going to be very interesting to me. We have three fantastic speakers with us here today. They're each going to speak for a couple minutes about the work that they do in the context of this panel, and at the end of each speaker speaking, we'll have a question and answer session open for the floor. We're going to start today with Emily Chan, who is a staff lawyer and does litigation and community development work at Justice for Children and Youth. Emily?
We have to pass the mic around, so bear with us. Okay, so I've been at Justice for Children and Youth for almost 15 years. I've been asked today to focus on police and youth relationships, and I'd have to say that concerns about those relationships started long before I got there and continue to this day. What I'm not going to talk about is the specific rights that young people have. What I'm going to talk about is the kinds of work that we have done, as well as I did bring one of our most popular handouts. They're all on the tables. They're red on one side, blue on the other. That has some rights-based information on it. It's one of the handouts we use in our presentations when we talk to you. There's other handouts there at the back of the table. I didn't know how many people come in, and they're all on our website, and our website is on that card, so you can always go there and download and order from us. What I'm going to talk about is the things we do as part of delivering legal rights information, and as well as giving advice. And what about some of these options around police and youth encounters do people have? And we're trying to encourage outside thoughts from other people on what else can be done, things outside of the box, outside of traditional legal avenues, what can be done. So in the group setting, we deliver workshops. They're usually in response to a request. The requests either come from teachers or from agencies where young people have raised some concerns with the staff there and they want to bring someone in to talk about it. In these workshops, we spend time on top of all the legal rights bits and pieces. We like to spend quite a bit of time talking about different kinds of communication and behavior styles and how that impacts that relationship with a police officer. So things like whether you're assertive or aggressive, whether you're rude or nice or polite. I mean, we always talk about how difficult that can be. We talk about how young people are the vulnerable person in that relationship. We talk about police abuse. And we try to talk a lot about different things to think about in that situation, trying to stay calm, and safety. Safety for us is one of the priorities for young people to ensure that they come out of it as least scathed as possible. We do have another card that we use in that setting. I brought one. There are statements for police, and on one side it has stuff about what my rights are, and then it's kind of a thing to give to the police officer saying, I know what my rights are, am I free to go? We don't hand these out generally, we hand these out in a workshop setting. We have had different responses from different police officers over the years about our handouts and our publications and the information that we deliver. A lot of it quite negative. So we want people to be really careful. We really want the young people that we work with to be careful. In the individual setting, either after these workshops or through direct calls from our office, we get about 2,000 calls a year. They're not all on negative police encounters. They're on a range of legal issues, but policing does come up regularly. So what we do is when we talk about their legal rights and their legal options, we also talk about the possible negative consequences of pursuing some of those options. So for example, if a young person is charged and outside of what they can do in the court process around their charges, we talk about whether they want to pursue a formal complaint, a complaint to the OIPRD. So that's something that raises a number of concerns, raising complaints. If you think about it in lots of other contexts, you might not want to complain about different people, and these folks like me are going to speak about different contexts. But in this kind of setting, we talk about, will it cause potential increased surveillance by the police, increased contacts by the police, more charges as they're increasing surveillance on you, and of course the risk of police brutality. So all of these concerns are really real, and we talk about the ways in this kind of setting, the adult allies, and how we can help young people in trying to address some of these things outside of these formal routes of complaints and fighting the charges. There's some agencies have collected stories and brought those to the specific police division involved and tried to communicate that way to let the police know, like, this is not something, like, these are stories that are consistent and coming from young people, many of which don't even know each other, but they all have the same stories. We did an affidavit project at one point, so we actually got sworn affidavits from young people about their stories and their encounters with the police, and wrote a formal report on that, and we use that regularly in trying to advocate for changes and protection of young people. Other ones would be getting it together. There's been protests in the past. Other agencies exist that can assist as well, like the Toronto Police Accountability Coalition, the Canadian Civil Liberties Association, and others like that. We always make sure that young people also do a bit of an assessment and think about what happened in the negative encounters they may have had. And the question is there some way that this could have been prevented or reduced somehow? This is unfortunately a victim-blaming focused approach, which won't solve the actual harms that have occurred. But it is one thing to talk about as part of all those other pieces. And finally, we try to ensure that the young person has access to psychological and emotional supports in the long term, short term and long term, depending on their needs. I'm going to stop here. That's kind of throwing out some ideas, hoping to give you some thoughts and ideas for your questions and comments.
Thank you, Emily. Our next panelist is Jordy Dent, who is the Executive Director of the Federation of Metro Tenants Associations.
Thank you very much. If you can't hear me in the back, just raise your hand. I've been told the sound quality isn't the greatest, so just maybe go like this, and I'll speak up. When I was on my way here today, I was trying to think of a good example, like a personal example, I could give you folks about difficulty in somebody trying to enforce their rights. And I got a text from a friend being like, hey, remember how I told you my landlord was evicting me so he could move into the unit? He just rented it out again. And this is actually pretty common in Toronto right now and in Ontario. And it's difficult because when she originally got her eviction notice, I was like, hey, you can challenge the landlord on this. All you've got to do is not move out, and then maybe the landlord's going to take you to court, and then you're going to roll the dice on whether or not you're going to get evicted, and I know you're pregnant, so that could be stressful. And she was like, yeah, I'm just going to move. Because enforcing your rights, again, is not always easy. There's no guarantee you're going to win, and it can take a lot of time and effort and stress. And now, even now, when she's realized the landlord's lying, has moved in new tenants to jack the rent, what can she do? Well, she can file an application at the court, again, take a day off work, try to find babysitting, and again, roll the dice in the hopes that the court's even gonna, find in her favor. You think it's a slam dunk case, but there's been many slam dunk cases that we've heard about where the tenant just loses for reasons that are, to us completely don't make any sense, but it happens. And I think this is a good example of the many different kind of reprisals that tenants can face in terms of accessing the system. And a lot of the reprisals are actually not just against, from the landlord. A lot of these reprisals are kind of personal kind of responses that a lot of people get, right? It's a lot of time, it's a lot of effort to try to force somebody to enforce the law. You've got to sometimes take days off of work to go to court. You've got to deal with the stress of putting together a case, which not a lot of people have experience doing. You don't always get access to a lawyer or like an agency that can help you with these things. So it can be very, very stressful. There's a lack of confidence. It can be very, again, difficult for people to do. And that's just, again, the self-reprisals. A lot of tenants who try to enforce their rights face many landlord reprisals, harassment, privacy violations. The landlord saying, well, I'm just going to start coming into your unit to take photos and look at things to try to find things to evict you. I'm not going to do repairs anymore. Oh, those services you used to have access to, I'm going to lock you out of them. Might evict you. The amount of people that we hear about where they say, hey, that rent increase is illegal. Oh, fine, then I'm just going to move into the unit. Again, it gets time and time again. But I'm not just here to be the bearer of bad news. There are some success stories. I just wanted to share with you a good one that was relatively recent from a tenant association in the Beaches East York area called 7 Park Vista Tenant Association. So this summer, this building went through, I think it's about 100 units. It went through what a lot of people go through, which is the landlord all of a sudden sending out blanket notices being like, by the way, air conditioning is $150 a season now. And just mass notice, people start paying, very few people push back. And the tenant association, again, had worked with our agency, worked with some of our staff, and knew, hey, we've got rights here. We have a little thing on our website that kind of explains what the rights are from our perspective. The problem is that the tenant association did some research and said, well, I found a bunch of cases where, again, the landlord and tenant board, the court, doesn't enforce these rights. So I was like, yeah, again, it's a risk. There's no guarantee that you're going to win. Thankfully, the tenant association had also just gone to our latest iteration of something that we run called a tenant school, where we normally give information about rights and responsibilities. And the latest iteration of the tenant school, which, by the way, was originally funded by the Law Foundation. Much better there. But the latest iteration also has stuff around civic engagement. So the tenants got on the horn to the CBC. And during a nice hot summer, again, with hundreds of buildings getting this every year, pointed out that they thought that these charges were illegal. And really pushed back. And said that, this was an outrage, people have been living here for 40 years not trying to play this stuff. And the landlord, a large landlord called Capri, just caved. Just immediately rescinded all the notices. There was a story in the CBC the next day. I think the landlord could have fought it in court, but I think this just shows another example of things that tenants can do, and that a lot of the communities we work with can do, which is just organizing. Organizing has a bad rap and is considered to be a dirty word by some people, but it's not always, a rah, rah, rah rally. It's just getting people together, again, to assert your rights, and using other tools other than the law to push the landlord. Organizing in Toronto from tenants in the last year has really tried to focus on strengthening laws so that it's not always incumbent on the tenants to go and do things. So the city now has got a new enforcement regulatory bylaw they passed. And that, again, puts the onus on the city to fine the landlord if they're not doing things properly, rather than forcing the tenant to go to the board. The landlord's own use thing that I just told you about, we've been hearing about that for years at the Federation. September 1st this year, the government just changed the laws to require that a landlord gives compensation. Fortunately, my friend missed the cut, so she's not going to get the money, but other people will. And I think this is just another example of using the law. You might face reprisals, but there are, again, other avenues, and sometimes you can organize to strengthen those laws.
That's okay. Thank you, Jordy. Our final panelist today will be Carl Flecker, who works as an immigration employment specialist at the Keys Job Center in Kingston.
Thanks, Abby. So late afternoon's a tough slot, and studies have shown that sitting is the new smoking. So I encourage you from that side of the room, maybe table by table at your own discretion, feel free to stand up and stretch your phalanges or other body part as you wish. It doesn't disturb me, and it'll be healthy for you. So I wanted to share a story from my workplace about trying to help newcomers into the labor market, ideally to find a job that's equivalent to what they had been doing in their source country, but I think most of us in the room know that's a fantasy more than a reality. So this story's got a couple of elements to it, 3 elements. National insecurity policies that are rooted in racial and religious profiling, human rights versus corporate and xenophobic interests, and systemic employment standards violations. So a little background. I met Sam about 4 years ago, bright fellow, highly educated, BA, MSc, working on his PhD in electrical engineering, new to Canada, got a family, headed down the path towards citizenship. He had a career in satellite communications and broad spectrum multi-satellite beam technology systems. Yeah, I get those every other day. Translated, that means he gathered international satellite broadcast feeds and he redistributed them to TV stations throughout his home country. He worked for the Satellite and Telecommunications Department run by the state in Iran. His job meant that folks could watch FIFA soccer matches, keep abreast of world news, culture, and entertainment. He wanted to work in his field, satellite telecommunications here in Canada. Not a lot of places doing that. Even fewer places in Kingston where he is living. Context. Satellite tech is a federally regulated industry, and Telstat's primary contracts are in the United States. They contract to build, maintain, or operate U.S. satellites. U.S. satellite tech, both the civil and the military uses, are regulated. It falls under the aegis of the U.S. State Department's Directorate of Defense Controls, or the DDTC. U.S. doesn't want their tech to fall into the wrong hands or to jeopardize their national security or foreign policy interests. So they get rules about who gets to access their tech. And these are called the International Traffic in Arms Regulations and or the Export Administration Rules, which fall under the authority of the U.S. Arms Export Control Act. You still with me? It doesn't get less complicated. So there's a very detailed list of what falls under these rules called the U.S. Munitions List. And that list is a slightly modified listing of items of tech that have both civil and military and defense applications that 41 countries around the world have agreed should not fall into the wrong hands, something that was derived from a thing called the Wassenaar Agreement. So how do you go about enforcing access to military and civil tech that the world uses, that private sector's players design, build, operate, or maintain, and that is global in nature? Well, the U.S. in its wisdom decided to create a list of countries that they deem to be rogue nations to their interests, and any contractor who works or employs people from those said rogue nations has to abide by their rules if they want to play in the sector with the U.S. Department of State. Satellite tech is in the sector. Samad is from Iran. He's worked with that government State Department to let folks watch soccer. What are the implications of what I'm talking about? Iran is one of 20 countries on the U.S. rogue country list. Today, about 100,000 Canadian workers are either in the aerospace, space, or defense industry sectors. You violate the ITAR rules, you're facing $2 million a day in fines and or 10 years jail time. Civil penalties, $500,000 per infraction, plus a denial of export license and a seizure of your implicated goods. Employers are going to be careful about who comes from where before they hire these folks. Up until 2011, ITAR openly discriminated against any worker who came from one of those 20 countries, called a dual or third country national, and made it very difficult. This was openly discriminatory. This meant that workers making military vehicles for GM under contract to the U.S. State Department and who had dual citizenship from one of those 20 countries could not work on the manufacturing line. They were sent home. And their co-workers wondered why. And the word terrorism was in the background. So human rights complaints were filed, time passed, settlements were reached, ITAR rules remained intact. Students studying aerospace tech or newcomers from, let's say, Venezuela or Haiti, for example, who worked for Bell Helicopter, Textron in Montreal, were denied employment, internship opportunities, or promotions in companies that held contracts with the US State Department because of ITAR rules. Human rights complaints were filed, time passed, settlements were reached, ITAR rules remained in place. I think you're getting the chorus here. So, long process, limited remedy, little justice. When I met Sam, I suspected his career plans were facing an obstacle. But it took him about 2 years for him to come to the same point of fully understanding what he was facing before he decided to file a human rights challenge. He had applied for more than 18 positions at Telsat. This guy is eminently qualified. He's a nerd. He was never given an interview, nor even the courtesy of a response to any of his applications. I helped him file an inquiry with Telsat about his applications and subsequently assisted him filing a human rights complaint via the Canadian Human Rights Commission with the pro bono assistance of one of Canada's leading human rights lawyers. A two-stage investigation by the Canadian Human Rights Commission revealed a lot of issues. Just a few highlights. Telesat dubiously claimed that he was either overqualified or underqualified for different positions. Some positions, they said, were never filled. No, we never filled them. But our investigation revealed they were in fact filled, but not from anyone who came from those 20 designated countries. A knowledgeable source within Telsat disclosed to us that Sam would never be hired due to the ITAR security screening protocols. HR personnel for Telsat asked him questions about his source country prior to even being considered for a position, which, despite their official claims, they say they don't do that. This indicated that they were fully aware that the ITAR rules and security protocols would prevent them from hiring him due to country of origin. Confidential documents that we obtained via WikiLeaks revealed that the US and Canadian governments had met on numerous occasions to create a sinister ITAR amendment that came into force in 2011. It provides the illusion that country of origin is no longer being used to discriminate against potential job seekers. But in reality, the ITAR amendment of 2011 substitutes overt discrimination for covert discrimination. The same documents revealed that the industry sector acknowledged their collusion in human rights violations. They said it's a part of doing business under the ITAR regulations, and their strategy has been, let's settle out of court, because if this makes it to the Supreme Court, the ruling would end them. This year, the CHRC mandated a conciliation hearing between the parties just a few weeks ago. Telsat offered I've written modest, but I think it would be more appropriate to say insulting sum of money to settle, and added the astonishing condition that Sam forego any future right to file a human rights complaint for any future job application for which he is qualified. Nobody at the conciliation or the commission had ever heard of such a condition being put on the table. He refused. We're requesting that the commission refer the complaint to the tribunal because of the public policy interests that are at stake. So what to do when the system really doesn't offer a remedy? Sam's never going to work in his field in Canada or the US. He's experiencing serious depression. Family stress is a reality, as is economic precarity. The commission process will take us until 2020 at the earliest. We began this challenge in 2014. Our odds of winning are low. At best, if we were to succeed, it would be about money, not meaningful employment. One is more important than the other to Sam. The US will never alter the ITAR rules, and they have said so. Canada's Controlled Goods Program and our Public Works Government Services Canada, our counterpart to the ITAR DDTC duo, has demonstrated that collusion is their preferred policy option rather than justice. What's our path to justice? Well, we're trying to raise the issue of this case with the International Civil Liberties Monitoring Group and some unions like the Public Service Alliance Commission of Canada. Our long-term strategy includes raising public awareness, seeking more damaging information through access to information requests, gathering the stories of other workers and students who are facing similar injustices, obtaining a supportive critique from some industry stakeholders who recognize that they are losing and suffering from the loss of international talent and the costly and unethical price of doing business, settlement versus hiring. We're working on building a legislative campaign to demand a review of Canada's controlled good programs. Idealistically, because why not? What else have I got to do? We're pushing for the Canadian government to break with ITAR. Or, and I have some other ideas, this issue is not a standalone matter. It's complex and it seems very distant from a lot of people's lives, but security screening protocols that rely on race and religious profiling under the guise of national insecurity is a rationale that is growing in many workplace sectors, provincially and federally. They don't call this struggle for nothing. Thank you.
Thank you, Carl. The panelists have got me thinking about a lot of the work that I do around advocacy and how a lot of my work is really specific to the legal context, but in many ways, my clients who are mostly vulnerable people need advocacy outside of the courtroom and outside of legal remedies, and sometimes they don't know how to access this advocacy. So a general question that I have for the panel is, how do vulnerable people who may have language barriers or deal with poverty or have issues in terms of their immigration status and are afraid to speak out or to seek help, how do they find access to community resources?
I know for our client base, the access has come through the internet mainly. So we've really changed our website in the last, I think maybe about 14, we did a total revamp to put in a lot more legal information. We have a way for them to call us as well as to email us with some questions. And so for us, our client base, we know is going online, and that's how we're trying to manage some access.
In terms of the people that access our services, we don't track everything in our agency, but we have pretty good tracking on our tenant hotline. And if you look at that, the top categories that we see are now, when I started almost 10 years ago, it was a bit more varied, but you're seeing a lot of web stuff. But the actual interesting thing is word of mouth is also really big, and I'm sure that would be pretty common for most of you. A lot of folks' social networks bring things out. I don't have any hard data on this, but anecdotally, I believe you see that a lot with like second language communities who access our services. Somebody will be like, hey, I called this number. They've got some resources in a different language, or they can help, or they're willing to do that. And things will often filter out through tightly knit communities around, which many of different types in Toronto. And then there are other groups, a variety of different activity groups, not just second language stuff, and I think you see kind of similar things.
Great question. To reiterate what some of my comrades are saying, I find that community leaders are very helpful in terms of connecting or speaking or extending the support, word of mouth for sure. Google actually sucks at this. I've mentioned that to my son who was working there, just because I need to be able to put a dig in every once in a while. But also frontline service providers can be helpful with this, but they need to be able to build their capacity and to be able to share what they're learning, because it's quite often it happens on an anecdotal basis or a one-on-one basis. And so we're not systematically building the capacity amongst the sector, I find.
This question is actually specifically for Emily. Can you hear me? Sorry, this has to be right up to my mouth. I find that in the work that I do with vulnerable people, they're struggling with so many things at the same time. They're struggling financially, they're struggling with sometimes leaving their families behind. when I do work with people whose children have been taken away by children's aid services, they're struggling with their families being broken apart, and sometimes CS's specific requirements require their families to stay broken apart in order for children to be returned to the home. So when I do community advocacy work outside of that, the struggle I have sometimes is sort of outlining the difference for vulnerable people between legal information and legal advice that they try to then act on because they're getting the advice from a lawyer. Have you experienced that struggle before, and how do you overcome it?
That might apply to all of us. The difference between legal information and advice comes up consistently. So, I mean, we try to explain it, especially online when we're doing stuff, when we respond to people or ask for lawyers, we provide legal information only. And what we try to say to them, like, this is generally how it applies to anybody. So this is a right that anyone generically has. So the right to remain silent, everyone has that. But then, if something happens in your situation, so the question is like, well, what if they ask me just for my ID? Do I have to speak to them? Or if they ask me my name, do I have to speak to them? Right? So that's where you're switching over to advice, because they're asking about how their legal right applies in a specific context. And that's kind of the changeover from an information-based legal rights session, like information, as well as when you're turning it over to the advice situation. We do get a lot of questions about, hypothetically, if my friend, and I'm sure that's a common event for all of us as well.
We have generally a very similar line, but ours is a little bit more malleable in the sense that what we often tell people is what the law says. So if somebody says, you know, hey, this is my specific situation, I'm like, well, here's what the law says, and they can put two and two together. You know, it's fairly simple. Oh, this provision in my lease is I can't have a pet. That's illegal. It's very clearly in the law. You know, with some occasional exception that I won't get into. But the point being, often the line that we use is this is what the law says, and this is what you can do. We never really use the word should, all right? Because that is advice, and so that's generally where we draw the line.
Maybe two quick comments on that. Just, Stephanie, because you mentioned that we're working with vulnerable people, and I'm often reminded that vulnerability comes in different forms. So we have the highly skilled middle-class newcomer, we have the tradesperson, and they're both face a similar type of vulnerability when they're trying to get into the labor market or they're facing an employer. So just being very mindful of that and their ability to be able to react to that class distinction. We also use a translation device, or as I call it, plain language, explanation of what we understand the legislative or regulatory environment to be. I find myself repeating it painfully slowly and on numerous occasions. I clarify, and then we test for comprehension because it takes time. We found for different clients at different points. I mentioned in the case with Sam, it took a long time for him to get to a point where he was mentally prepared to take on the kind of challenge that meant his career would be down the toilet. And that was not something that happened overnight. And there's still moments of remorse for that. So it's not a 30-minute session.
I have one final question for the panel before I open it up to the rest of the floor, and this is specifically about language barriers. A lot of us work with immigrant populations or for people for whom English is a second language, and even beyond that, I can say, at least from my practice, law is a third language. People don't really understand what most legal terminology means. Even as a lawyer, I'm often, reading contracts or reading case law, and it can be confounding. And so I can't imagine what self-represented parties experience or people who have to navigate the law on their own. And certainly there's an additional layer to that when they don't speak English or French and they can't understand the language that they're expected to follow. How do you help your clients overcome challenges like that? I realize that's a very broad question, but there may be ways in which you can talk about how community advocacy can help in terms of overcoming those challenges.
So I'm reminded of a project that we're doing extra appreciation and thanks to the Law Foundation, legal training sessions for frontline service providers and community leaders on different aspects of immigration law, racial religious profiling, employment standards, and OH&S. And so one of the parts is actually these seminars having a qualified interpretation at the sessions, deliberately bringing in people from the community who have multilingual skills into the capacity building sessions. Those are, I think, very small measures, but important measures to be able to help with comprehension and the challenges between, the idiomatic nature of language and how people interpret that. It's a big struggle because, the other day we were just at Innovation Park, a place in Kingston that's doing some interesting scientific research, and we learned of a new startup company that has actually developed software to take scientific documentation and make it into plain language. And so, wow, talk about a new application. How about taking, the legal code and making it into English?
I don't have much to add other than I think, for me personally, I think when I started at the FMTA, I was guilty of just kind of reading, I just read what the law says and hope somebody understood it. I think a lot of that just has to do with time and experience. Over time, you learn effective ways when you repeat something over time, kind of a way that somebody obviously can understand it. So at our office, all our staff have kind of a catchphrase that they use, or specific ways, and or coworkers say something, and I'm like, oh, that's a good way of describing that. And a lot of times it's just experience.
All I have to add to that is we do use translation services. And on top of that, we would, the clients that come to us often come with either friends or family members. That might help, but we always insist on making sure there's a formal translator because of the legal language that's really different.
Right.
The other language that we use.
Right.
So it's to make sure things are coming across in plain language. We always write things down. If anything, we try to do things more in a flow chart. So if you look at the yellow book, we also have a lot of public legal information pamphlets that we give to them as extra support to look at. But like flow charts, right? So you want something where they're able to say, okay, step 1 is going to be this, step 2 is going to be this, and you want to use not too many words, and you want to encourage them to write anything down, ask questions, to clarify, and you have to be open to people coming back to you more regularly for clarification and for communication, just to make sure that they understand this.
I'd rather have somebody understand me asking me the question 10 times than not understand me when asking once. We're going to open the floor to questions. I'm sure the room is burning with questions for our panelists.